Hi guys, it's Kathy. I hope you're doing well. We have sound. Man, I woke up this morning to a ton of copyright violations from YouTube. Hundreds. I violated hundreds of copyrights last night. Yep. It was fun though. It was great. I gave everybody a headache though. Everybody left the live stream with a headache. It's fine. I'm not going to monetize that video, so it's not a big deal. It's perfectly okay. Nothing against my channel. It was just that one video saying you can't monetize this. You can't monetize this. Yeah, I know. I do know. My members only videos are never monetized ever. I never monetize them. So if you see ads, that's YouTube. That's not me. I cheated a little bit for today, but you might not notice, or we might notice. We're going to find out. But first, I did find some pretty good clips before I fell asleep like 40 minutes ago. Oh, he already looks like mad, doesn't he? He already looks like Clint Eastwood. Do you feel lucky? Well, do you, punk?
Paperwork.
Broncos. All right, I was making sure that wasn't the Chiefs.
Yeah. Oh, did he? Okay. Oh, perfect.
This was one of Dan's.
Yeah. As long as he e-filed the paperwork.
Yeah. I believe it.
All right, 24 CR 5610, People versus Locust entries.
Sam Romano for the People, covering for Daniel Cohen.
Josh Lindell on behalf of Ms. Locust, who appears with me on bond. We should have a proposed disposition impending.
You have to listen to it all. You have to listen to all of it before you make a decision about her. And he thinks a lot.
You know, I work every weekend looking through this stuff, hoping to find these things filed ahead of time so I can actually prep.
Yep.
That poor lawyer didn't realize he just got yelled at. It is on his desk. It is. He moves his camera a lot. We're at a whole nother side of him. Are they flowers on his bow tie? Let me look. I can't play it now, but
All right, Ms. Locust, I've got paperwork here indicating you wish to plead guilty to count of assault in the third degree, a class 1 misdemeanor. Looks like your attorney and the DA are asking me to accept a stipulation to probation. Any jail as a condition to probation would be up to the court. Are you understanding of what you're doing today?
Yes, sir.
Counsel, will you further advisal under Rule 5?
So waived.
All right, and you're Susan Locust?
Yes, sir.
All right, speak up, pull that mic. You have to hold it if you need to. How old are you?
43.
And how far did you get in school?
1 year college.
So I presume then that you read, speak, and understand English?
Yes, sir.
Veteran of the United States military?
No.
Under the influence of any drugs, alcohol, medications, anything that'd be affecting your judgment today?
Sir.
Counsel, you have a constitutional obligation to find out the citizenship, nationality of your client, and if she's anything other than a U.S. citizen, you have an obligation to tell her the immigration consequences this plea would have on her status. Are you in compliance with your obligations?
I am.
The count to which you are pleading guilty reads that on September 16th, 2024, you did unlawfully and knowingly or recklessly cause bodily injury to Louise Bradley. To that count, do you plead guilty or not guilty?
Guilty.
All right, before I accept that plea, let's make sure you understand a couple of things. The class 1 misdemeanor carries a potential sentence to the county jail of up to 364 days. Now, I know your attorney and the DA are asking me to accept a stipulation of probation, but even if I accepted that stipulation, if you violate probation, you're coming back and you're facing 364 in jail.
Yes.
So that number is a real number.
Yes.
You understand that?
Yes.
Oh my God, there's Linus.
And she have the paperwork there in front of her?
She does not, Your Honor.
All right, ma'am. The other thing I want to talk to you about, other than sentencing ranges, are the rights that you have. You have the right to plead not guilty. You have a right to have a trial within 6 months of that not guilty plea. You have a right to be represented by your attorney at all hearings up to and including trial. You have the right to be presumed innocent of the charges. You have a right to have the district attorney prove the charges beyond a reasonable doubt. At a trial, you have a right to confront witnesses. That means you have a right to question them, to cross-examine them. You also have the right to present evidence in your own defense. To that end, you have a right to have me issue subpoenas ordering your witnesses to come to court and testify during your case in chief. You have a right to testify or not testify in any trial. And if you chose to remain silent, I would tell the jury that they could not use your silence against you. Finally, if you went to trial and were convicted, you would have the right to appeal that conviction to a higher court. Do you understand that you have all of these convictions? Or, pardon me. Do you understand you have all of these rights?
Yes, sir.
Do you understand if I accept your guilty plea, you will be giving up all of these rights?
Yes.
All right. Now, finally, ma'am, I do not accept pleas of guilty from people who tell me that they're innocent. That's what trials are for. So now I'm going to ask Mr. Walton to tell me, Mr. Romano to tell me what facts he would prove at a trial that support this charge. And when he's done, I'm going to ask you if that's what happened. Counsel.
Your Honor, on the date and time charged, Miss Locust and the victim got into an argument about a ring that the victim accused Miss Locust of taking from her. Miss Locust then proceeded to punch the victim multiple times in the face, causing a substantial risk of serious injury to the victim's eye.
Is that what happened?
Yeah.
Well, understanding the rights you're giving up, understanding the potential penalties, you still want to do this?
I'm ready to get it past me.
That's not my question.
Yes, I understand.
I can get it past you by setting a trial.
I understand.
You want to enter into this plea today?
Yes, sir.
All right, then I'll accept your plea. Finally, you've entered into it knowingly, intelligently, and voluntarily. It's a sentencing prosecution.
Your Honor, I will first note there's no restitution and we are VRA compliant on the plea. As to sentencing, the people would ask that the court embrace the stipulated probation plea agreement. At this time, the people are not requesting any jail as a condition of probation.
There is where I'm going to ask why. I think if there is a time for the system to be more protective, it's crimes against children and crimes against at-risk people. And this person's wheelchair bound and was broken to the point, it was beaten to the point of having facial fractures. I'm having a hard time understanding how that's not jail.
Your Honor, I understand the court's position.
I don't take positions.
Sorry, I understand the court's comments. And I'll just note that Ms. Locust has no criminal history. She's here to take accountability for her actions. In speaking briefly with Mr. Cohen about sentencing, and who he has obviously had more hands-on with this case than I have, he also indicated that he was not requesting jail. So that would be our request. What I was going to note, however, is that just briefly looking at this case, I see at least one notification from pretrial services that there was a lack of contact. And I also am seriously concerned about the facts of this case, even briefly reading the factual summary in our notes. And so what I would
Hold on, guys. You got to hear everything. You got to hear it all first.
say is I will abide by the request, obviously, of the assigned district attorney, and just note from Ms. Locust that I think that if this comes back on any sort of revocation because of non-compliance, because of not contacting probation, as it looks like there might have been some issues with pretrial, the people will not be re-granting probation. We'll be asking for a substantial jail sentence. And so I do think, based on her criminal history and based on taking accountability, that it's appropriate to sentence her to probation without any jail. However, that leniency would not be imitated on a revocation.
Mr. Lindell, you know my concern.
Yes, Your Honor. I think one thing that's not captured so much in the initial reports here is there was some level of mutuality in the combat. Ms. Locust was hit during this altercation as well. I understand.
I'm trying to figure out the mutuality when she has to go up to the person in the wheelchair and start hitting her because she didn't get out of the wheelchair and attack the defendant.
My understanding of how
Yes, if someone in a wheelchair is getting hit, she's going to hit back.
Yes, and my understanding of how this started was she was in the wheelchair. They were communicating in very close proximity. She was hit. She reacted by hitting, and it escalated from there. It's a situation in which this is a very gray area. There are no independent witnesses. It's what she said and versus what she said. However, the important thing for this point is Ms. Locust has no history of this and has expressed in my conversations with her no contact with this individual, no desire to contact this individual, no desire to get into any trouble.
I'm not really worried about that. I mean, obviously that's a concern, but anybody who would attack and break the facial bones of someone wheelchair bound is someone I have to worry about. That's what I'm wondering about.
I understand, Your Honor. I think for Ms. Locust, learning how to handle and de-escalate these situations is going to be the most important thing, and that's what probation is going to get her. There's, as far as the exact how it played out, it's not captured. We were not there. My understanding was that this was mutual. Both parties walked away with injuries, though hers were much more grave, and Ms. Locust is taking responsibility for that. It didn't have to escalate the way it did. She knows that and is not going to do it again. We would ask if the court is inclined for a further stick in this matter to suspend an amount of jail, even the max amount of jail, on completion of the probation, rather than putting Ms. Locust back into custody today, as she is in a good position, has not gotten into trouble. There's the blip on pretrial, but I believe she's gotten back into compliance since, and is just trying to stay quiet, stay out of trouble.
Ma'am, you have the right to tell me anything you'd like me to know before I sentence.
Oh, sorry, sir. No.
I'm really struggling with this one. So I can't imagine what someone in a wheelchair could possibly do to you to make you break their face. Issuing a beat down on a person who's in a wheelchair.
She wasn't in a wheelchair, sir.
Well, what the facts I have. No one's contested it yet.
That's the first I heard that she was in a wheelchair. She wasn't in a wheelchair at all.
Prosecution, that's not what the affidavit and everything say. Defense didn't.
I'm sorry, Your Honor.
That's what the affidavit for warrantless arrest says.
I believe when she was contacted, she was in a wheelchair. We don't have firm confirmation either way at the time this started that she was. I don't believe she was wheelchair bound, but a lot of folks use wheelchairs now.
I was on crutches at the time.
And she was on crutches at the time. That is on body.
I've been on crutches. I'm not worried about that.
Judge doesn't care if you were crippled with your crutches. He only cares that she was crippled, even though she was not crippled at all. They both really did walk away.
All right, I'll give you some credit for your lifetime so far of no criminal history.
Thank you.
Now, you can thank me by one way. Successfully complete probation, don't come back. Because if you come back, you're going to jail.
Oh, I can guarantee I will. Completed, yep. Successfully.
All right, well, enter a finding of no pecuniary loss. We'll sentence you to 2 years of probation. There's probably going to be an anger management class. I don't know anything you've already done might be given credit for, but any terms and conditions your probation officer tell you to complete, get it done.
Okay.
If you're a rock star on probation, then, and I get a motion for early termination, I grant those. Otherwise, you'll be on probation for 2 years. And I've already told you in a case like this, as I understand things are, you violate probation, you're going to jail.
Mhm.
All right, go to 303 West Colfax. That's catty corner from here. Check in with probation, and get that started. Good luck.
Thank you.
Y'all
Your Honor,
judged
if I could
her.
call Mr. Mallon.
Y'all judged her for hitting a girl in a wheelchair, and there was no girl in a wheelchair, and she was on crutches. Jeez. Okay, next one. When he thinks this long before he even calls the case, you're in trouble, mister. Things are not going to go well for you, mister. Thumb wars. Yep. Yep. He's reading through the criminal history and the case.
All right, 25 CR 456, 24 CR 293, 24 CR 5152. People versus Sands. Entries?
Tom Walton for the people.
Ben Britton on behalf of Mr. Sands, who appears in person in custody at the podium with me to my left.
All right, what are we doing on the arraignment? 25 456.
All right, in that case, I'm sorry, what was the case number you just read?
25 CR 456.
Thank you. In that case, we'd be entering a not guilty plea.
All right, speedy trial September 4th, 2025. Motions due March 24th. That's 25 CR 456. Let's do a disposition April 28th. At 8:30. Hearing on motions May 2nd at 2. You want to set trial today?
I think we can toll until motions.
I wonder what he's looking at in the ceiling.
Then speedy is November 3rd, 2025. All right, and that leaves sentencing on the probation revocation of 24 CR 239 and sentencing on 24 CR 5152. To that end, I have reviewed the PSI dated February 20th, 2025. Any additions or corrections?
Nothing from the people.
Defense?
Just, it appears that the pre-sentence confinement calculation might be a little bit off. I know that there's substantially more time than what was calculated in the PSI that I see of the 50 days. I would just, being that that's somewhat trivial to sentencing an argument, I would just be requesting to file a motion with a proper calculation.
Okay. Mr. Walton?
Thank you, Your Honor.
Well, I've yet to meet any defendant who thinks pre-sentence confinement credit's trivial, but
Well, correct. I just mean
I
for
know.
what's going to be
I know
presented
what
in
you
court. Your Honor, and I apologize, but before we get to argument, just for the record, it would be defense's request to ask for a continuance of sentencing one time, understand the court's reluctance to do so, simply because I expect the people's argument is going to, in large part, talk about this new 25 CR case that is now pending. I do believe there's more investigation that defense needs to do to.
he's not guilty on that.
Correct. I'm
not listening to any argument about the new allegations.
Okay. With that record, nothing further.
With respect to 24 CR 5152, the plea in this case did contemplate dismissal of two other cases with similar dealing charges. Of the three newer cases, only 24 CR 5152 had any significant weight to it with 19 grams of meth. The other two cases were smaller amounts, but did also involve allegations of dealing. We entered into this cap with a particularly long set out for sentencing and agreed to a PR bond for Mr. Sands. When the plea entered, because Mr. Britton did a lot of work to set up a possible sober living situation to show that Mr. Sands could be successful in the community. Sadly, it took less than a week after that for Mr. Sands to be picked up on new charges. The allegations in that case, while unproven, do involve a sale of drugs once again with a marked bill that was found in Mr. Sands' possession. The PSI itself in this case is a little bit disappointing. Mr. Sands doesn't seem to take any real responsibility for his actions, trying to brush off his possession of the meth in this case as meth that he was simply transporting in hopes of getting meth from somebody else. As far as excuses go, it both ignores the gravity of the situation, the consequences of his actions, and sort of fails to actually change the elemental aspect of all this. Given everything, people just do not have any faith that Mr. Sands is going to be successful on any kind of community-based sentence. Every single time he's released from custody, he goes and sells and is picked up again in a very short amount of time. We would ask for the full 8 years Department of Corrections.
Defense?
Your Honor, so starting first by addressing kind of the pre-sentence investigation report and the people's concerns with it, I believe that one interpretation of Mr. Sands' reporting of what was happening that day and the methamphetamine that was found on him might be that he's not taking responsibility, but I also believe that it is, in honesty, him admitting to the fact that he has a substance misuse issue, and it was largely affecting both what has happened in the past and what was happening during the time of these charges. I think his ownership and responsibility of it is saying, yes, I've had a problem. I was personally using the substance and I got involved in a situation that is not conducive to what he wants to do and his plans and goals and what he wants for his future. As the court can see, he has had a lot of things happen throughout his life. I've made a number of records when talking about bond and everything else relating to what happened in Florida, the circumstances and the time period in which he went into prison.
No, Florida was yesterday. Let's not think about that again. And the perfect audio.
For the first time for an extended period of time. Prior to that, though, he has been an extremely successful young man who had great baseball prospects, who was doing largely well in his community and kind of on a bright trajectory. Unfortunately, with the underlying substance misuse issues, he is recognized and is taking responsibility for the fact that he needs to get into some sort of help or treatment or oversight or something. Largely, he will be affected by incarceration with his actual physical medical issues. He does have high blood pressure. It was reported, and I saw from some documentation visiting him that he did have kind of a mild stroke and mild heart attack while he was in custody. That got him onto a different high blood pressure medication, which was in large part our hopes of getting him out. I know, drugs obviously are not conducive to dealing with medical issues like this, but DOC absolutely isn't either. So I'm hoping the court would consider something that would potentially be a middle ground to allow him to have the oversight and the responsibility he needs to be taken, being monitored by somebody else through the potential ability to go to community corrections while also still having access to medical treatment so that he doesn't end up in a place where he is significantly injured or dies in prison. Should the court not be amenable to considering community corrections, we would be asking for something lower than the cap that was contemplated in this agreement. Understand that he's still going to have a significant parole sentence when he comes out the other side of this, and especially depending on what happens in the other case, although that's absolutely not admitting to anything or any of the allegations contained in the complaint there. Defense would be asking for a 3-year DOC sentence if the court is unwilling to consider something outside of prison. However, I do believe with everything that he has going on and how upfront and just honest about what he's trying to fight and get through as far as addiction, he is in a place where, should he really recognize this, he has a lot of potential. He has a lot of potential for employment, to be an active and strong member of the community. And should he be able to overcome kind of the underlying issues that have led to these cases, he has everything in the world going for him. He's a young man. He very much can be successful. So I think something that reduces incarceration but maintains oversight ultimately is going to be most beneficial for Mr. Sands. That would be our request.
And here we go, guys. This is why he was looking at it so hard. He has to look at it hard.
All right, so you have the right to tell me anything you'd like me to know before I sentence?
Throughout the time I've been in custody, sir, I've been doing a lot of thinking, and just recently you did give me an opportunity to step out to show my potential while being out in society. I was doing the right thing. I did go check in as asked to go with pretrial and take care of the matters at my rapper hold situation. I was picked up, unfortunately, in this case.
That one's pending. It is advising not to talk. So any other action, Darby?
Okay. Well,
It's obvious he was picked up after I let him out. I know that.
Correct. I'm just giving further advice.
okay. Well, I was doing the right thing, sir, and I would appreciate if you could spare me another opportunity, sir, to be successful in society. I just moved from Florida. I'm out here to take care of my mother. I'm my mother's only child. I was being her caregiver. She's in Longmont at the time, but she got married. But, I moved out here with my fiance, Lourdes. She's in the stand behind me. And it's just her and I, sir. And if you could give me another opportunity, I really appreciate it.
Okay. So far, he's done nothing to get himself out of the trouble he's in. The judge didn't take any of that into consideration. But he is thinking about something else, the judge is.
The problem I see is, one, not many people come before me who have actually taken another human life. And you got that manslaughter conviction. And then the sheer volume of cases, thinking about the ones that are being dismissed, in this case, what's appropriate. I really, one thing I don't understand is asking me to think about your mom. If you weren't thinking about your mom when you're out doing this, if you were thinking about your mom, you wouldn't have been doing it. If you're at home taking care of your mom, you wouldn't be out doing this, picking up this case, making me make these decisions. So if you're not going to think about your mom, don't ask me to. Look, I believe that people who are selling drugs, you need to work DOC time into your business plan. That's part of the cost benefit. And when you start doing your spreadsheets. So I am going to sentence you to 4 years in the Department of Corrections. Your attorney will will file a motion for pre-sentence confinement credit. On the DF2, there is a 2-year period of mandatory parole. You do have the right, under limited circumstances, to appeal the sentence I have given. You'd have to do that. Oops, pardon me. You've got 35 days to get that filed. 49 days. It's 49 days under Colorado Appellate Rule 4. And then you've got 126 days under Rule 35 to seek a post-conviction reduction in sentence. On the DM1 in 24 CR 293, we'll sentence you to 180 days in the county jail. That'll be concurrent with the DOC sentence in 24 CR 5152, and that sentence may be served in the Department of Corrections. We will need a virtual writ from DOC for 428 in 25 CR 456, and we'll need an in-person writ for May 2nd. All right, anything else from the prosecution?
Nothing further.
All right, I guess no restitution.
Correct.
All right, we'll see you back for your last trial, for your last case, sir.
Thank you.
Yeah, he's a murderer. That's why it took him so long at the beginning to look through everything and make sure that he had everything right. And that guy got super lucky because normally on something like this, he goes with whatever the prosecution asks for. What do you want? Just tell me what you want. You don't even have to tell me why. And the prosecution asked for 8 years. And he sent him back for 4 years.
Your Honor, when the court's ready, could I call number 80, Mr. Alamim?
I'm sorry, Mr. Alamim.
Afternoon.
Good afternoon, sir. All right, number 80 on the court's docket, 24 CR 5117. Entries.
Sam Romano for the people.
And Mr. Alamim is recommending representing himself. You're set for disposition today. I don't see any paperwork, so are we just setting trial?
We are, Your Honor. I am hopeful after speaking with Mr. Alamim that we will have a disposition at pretrial. I attempted to contact him in the interim between the last court date and today, although it looks like he got a new phone number. So we've updated contact information, discussed potential offers, and I do think that we're almost there. So Mr. Alamim just wants to consider some of the potential collateral consequences of that offer.
You mean non-collateral or actual collateral?
I don't
Immigration's not collateral consequence.
No immigration, Your Honor. Not an immigration consequence. I should say he wants to consider how a potential conviction could affect his future, not related to immigration.
Mr. Alamim, I recognize that the motions you wrote were, I struggle to find the right word for it. Obviously, you used AI. They were much better than what I would normally expect to see from a pro se person because of the use of AI, but AI is not going to be able to help you out in trial. AI is not going to be able to do voir dire. AI is not going to be able to do an opening statement. You sure you want to do this on your own? You sure you don't want to get someone on board with you to at least help you with the trial?
That's definitely one of the considerations that I'm having right now. If I don't accept the offer that the DA has offered me and we go to trial, I guess I can do the paperwork in the meantime, but I probably will need.
Well, you got to get that done because we're not going to get to the eve of trial. Look, any attorney worth their salt isn't going to pick up a case and try it with like a month to prepare.
No, I don't expect him to try the case. Mainly for advisory counsel, but.
Well, you're not entitled to advisory counsel. So just for our Constitution, you're not entitled to advisory counsel.
And Your Honor, one thing I will note, it's obviously Mr. Alamim's right to set for trial, but if the court, given the potential for counsel, if Mr. Alamim wants a trial, and given that I think we are close to a disposition, if the court would be willing and Mr. Alamim would be willing to set for one more disposition date, I think that we can have a more firm idea of what we're doing by that court date, even if it's just 30 days away. But the people are comfortable either way. I mean, we'll be ready for trial if necessary.
You want me to set the trial date or you want me to give you 30 days to work things out with the DA if you can?
You can set the trial date.
All right.
I have an issue other in case we do go to trial. I just noticed that even the homeowner wasn't on the witness list for the DA. So my plan was to request subpoenas for Mr. Sherman, his girlfriend, and the neighbors next door. I think they're 2441. No, that's the house that was burglarized.
Sounds great. Why are you telling the judge? That sounds like a great plan. Why are you telling the judge?
The address eludes me right now, but it's the house right next door. I need them subpoenaed.
Well, you'll have to file the appropriate paperwork with the court. And this is one of those situations where having a lawyer would really help you.
I got them right here. I just don't have time to do them this morning. I can fill them out before I leave the courthouse today.
And Your Honor, it's worth it just to, I think, correct the record. Mr. Sherman is on the people's witness list, or at least endorsed list of witnesses, I should say.
About July 1st for trial.
Thank you, Your Honor.
People can accept that date.
All right, we'll set it for 3 days just in case.
I'm going coffeeless.
Hopefully
today.
nobody had Bastille Day plans.
Bastille Day plans.
Steel day plans.
Other than me.
No one did. No one other than you did, Judge.
Oh, first is Canada Day. That's right.
Canada
My
Day.
celebration's confused.
51st day.
I set our pretrial conference for June 23rd. At 8:30.
Did you say the 3rd, sir?
23rd. All right, June 23rd at 8:30 for pretrial, July 1st. I'm going to set trial for 3 days with a standard veneer. We want an earlier disposition date, like April 7th, just to get you guys talking to each other, or
I'd
if
request
there's
that,
anything
Your
for us to do, or
I'd request that, Your Honor. That way we can hopefully.
I'm not trying to just drag you into court to drag you into court, but if it'd be helpful, I'll set it.
That's fine.
All right, April 7th. Can do 8:30 or 1:30, whichever you prefer, sir.
1:30 interferes less with my work schedule. So
All right, so April 7th at 1:30 for disposition. You're representing yourself, so if the DA can't get a hold of you, he can't negotiate or clear things with you. So if you get another phone number, if it changes or whatever else, you probably ought to reach out to him and let him know. All right, we'll see everyone back April 7th.
thank you, sir.
I think we're ready on a couple of interpreter cases for the afternoon. We can start with number 86.
Unfortunately, guys. I mean, I'm going to be ready April 7th. I really am. Unfortunately, he is probably going to A, get a lawyer, and B, take a deal before then. We're not going to get to see this trial, though I desperately want to. I don't remember. I don't think that the last 3 minutes count. So I'm going to move on to the next one. We got one more from this judge until we move to a different courtroom. A different judge. She goes with you.
And Your Honor, if I could call Mr. Solace from the afternoon docket, number 91.
I'm sorry, you said 91?
Yes.
I told you, this guy's dockets are 100 some long. He's on number 91. And you see how long he took with the people that we saw today?
'24 CR 2894, People versus Solace. Entries?
Tom Walton for the people on behalf of Mr. Cohen.
Anthony Vigil Martinez with the Public Defender's Office on behalf of Mr. Solace, who appears on bond to my right.
Oh, there he is. Okay.
I missed it all.
Well, we continued because I was told we had a plea, but I don't see paperwork.
And Your Honor, we did, Mr. Solace, a caseworker involved.
If you did miss that, like I did, Judge Fleischer, I heard, was very spicy at the beginning of the docket. Go to American Courts. He has it.
Mr. Solace's children contacted me today. He anticipates one of his children being charged with an F1 in juvenile court tomorrow. he has another child in competency proceedings. That has made our offer potentially untenable. I am, frankly, Your Honor, I'm prepared to enter a not guilty and toll until motions, given the length of this case. I think that we can provide that information very quickly to Mr. Cohen if the court is comfortable with a continuance. Ms. Vivian Burgos, the caseworker, did give me personal contact information, and so I think I can expedite that process.
Yeah, the other one has competency issues. No, the F1 is not an adolescent, I don't think. And you'll see why I don't think so.
Mr. Walton?
No objection to the continuance. So defer to the court on how to address the timing, whether we enter a plea or just set for another arraignment at this point.
Well, I guess I really don't understand what the words mean, that the offer is now untenable given what has happened to his son. I can imagine your son being charged with F1 is a huge deal, but I don't know how this affects that.
What it really boils down to, Your Honor, is that the juvenile child who is in competency proceedings does not have care.
See, that's why I think he's not a minor. He was going to take care of the son while he was in jail. Now he's
And so
in
at a
jail.
minimum, we're trying to figure out what we can do with respect to housing for that child.
All right, and so then what does that have to do with whether or not he pleads? Because even if he pleaded today, we said over sentencing, you can buy time with sentencing, this, that, and the other.
And Your Honor, given that the plea here, the offer is a restart with 90 days of Denver County Jail, which would be mandatory there. The issue is whether or not we can find long-term care such that if and when that becomes the reality, Mr. Solace's son is set up for success. And so I guess...
Well, I haven't seen anything come through. Well, wait a second. All right, since I last had to tell Mr. Solace to be perfect with pretrial, I've got nothing new that's come in. So that's good. It's a lot of stress in your life. You start drinking, missing UAs or anything else, you know, I've told you before, I'm revoking your bond. Right? Yes?
Yes.
Don't fall into that trap.
No, I haven't talked.
Don't deal with this through drinking or drugs.
Yes.
Do not go that direction.
No. I haven't done it in a year.
Well,
More than a year.
that was April 7th for continued arraignment.
That works for defense.
That works for the people.
You want 8:30 or 1:30?
8:30, please.
8:30 in the morning, continued arraignment on April 7th. Solace, my heart as a father goes out to you. Don't make that situation worse by messing this up and making me revoke your bond, because I won't hesitate to do it.
Yes.
We'll see you on April 7th.
Thank you.
Mr. Steinberg.
Number 85.
How's it feel being green?
Daniel Gomez?
Yes, sir.
All right. 84 and 85, yep.
Yes, sir. Where we're at is judge sentencing. This is a, if you will, change of vacation status on the 20 case.
Yep.
And then 24, we pled to a misdemeanor to run concurrent. I should tell you, he's entitled to 595 days of pre-sentence confinement.
Hold on a second, I want to get them on the record. All right, numbers 84 and 85, 24 CR 15103, 20 CR 5608. Entries.
Tom Walton for the people on behalf of Mr. Mann.
Judge Harvey Steinberg appearing with and on behalf of Mr. Gomez, who stands to my right in custody, sir.
Wow, Jim. 9 months.
All right, so we do have the change of address in the 20
We could
CR
add a baby.
5608, and then the escape, which I think is just a 120 concurrent.
All that is correct.
All right, and you were telling me about pre-sentence confinement credit on the 20 CR matter?
595. And that should also, a number of those days should be the 24 CR, since he's been in custody on that for an extended period of time as well. Although I think that the sentence in the 20 case will be controlling.
Anything to add, Mr. Walton?
Nothing from the people.
One additional thing, Judge, if you recall at the time of the plea, it was important to the defense that the court endorse on the minimus that the count that was the underlying count in this case was not a crime of violence. It was originally under the quote choking portion of the second degree assault, which is clearly not a crime of violence. The court indicated it would put that in the minimus, and we're just reminding the court that that's important to us, and we'd ask that be done.
Yeah, it's extraordinary arrest, but it's not a crime of violence.
That is correct. And the Department of Corrections doesn't seem to agree, so we thought that this might prod them in the right direction.
All right, 20 CR 5608 on the non-crime of violence, second degree assault, strangulation, class 4 felony.
Isn't that crazy? Isn't that just crazy? Yeah. Choking is non-violent. I don't know if that's just a Colorado thing or everywhere.
I had sentenced you, sir, to 5 years community corrections concurrent with count. The 2 counts of strangulation? There was counts 9 and 10? It's 2 counts in that case, right?
I don't know, Judge. I was not the lawyer.
Yeah, it was 2 counts. Yeah, it was 2 counts on that case. They were concurrent. So each of those sentences will be converted to 5 years in the Department of Corrections. There's a 3-year period of mandatory parole. I agree with Mr. Steinberg that the second degree assault strangulation is not a statutory crime of violence. And we will note the 595 days of pre-sentence confinement credit. Okay.
I don't know who you're talking about, boys, but I'm sure they learned their lesson.
No, he put that in.
The ComCorp complaint.
Yeah. He said that. So the explanation was because they're every day. No, we're just doing it for the minimum. How much that was custody here versus custody at community corrections.
Yeah, but the problem is they're saying it's not
So the
violence.
ComCorp complaint was filed March 7th of 24. Well, And we should have 460 days of pre-sentence confinement credit and 135 days of incarcerated residential.
Yes, sir.
All right, so it's 460 and 135, Andrew.
Which is 595.
Right. The keeper of the red tape says it has to be
Yes, sir.
teased out, so. All right, and then the 24 CR 15103 sends to 120 days in the county jail. That may be served in the Department of Corrections, as it will be concurrent with 20 CR 5608. And he's been in custody since August of 24 on this case. So he easily has over 120 days of pre-sentence confinement credit on that case. Anything else, Mr. Steinberg?
No, thank you so much for your time.
Have a good day, sir.
You, sir.
Pleasure.
Thanks.
I don't know where all that niceness came from right at the very end. But the judge can be nice sometimes. Okay. Now I'm going to cheat, guys. Listen, the stream ended late, and I didn't have a lot of time. I had like 5 hours to get a 2-hour docket together, a 2-hour stream together. So what we're going to do is we're going to watch. I didn't pick and choose from this docket. I'm just playing Georgia, and we're just going to watch Georgia for a little bit and then go about our day. No OJ today. I got to work a double, but I need to work a double, so that's good.
Out of the fact that you have entered a guilty plea to a felony in this matter.
I have no idea what's going to happen in this docket. I did not have time to go through it. So hopefully it's not too bad, but it's really bad.
Upon this sentence becoming official, you'd have 4 years from that date in which to file a petition for habeas corpus if you feel your constitutional rights have been violated in any way. Let's let the plea begin.
They are very, very cute, especially little baby ones. Oh boy, he's typing. Is he typing? What's he doing on his computer?
Anything further from the state in regards to Mr. Reynolds?
No, Your Honor.
Mr. Deal, on behalf of Mr. Reynolds, anything further?
No, Your Honor.
All right, that'll conclude this matter. Good luck to you, sir.
Thank you, sir.
Remember that lawyer that, oh gosh, I played a lawyer recently. There was a total ass to a father that was on the stand. He was really good. Throw his paper around, and I had another case with him. But again, I couldn't play it because apparently he only prosecutes terrible crimes. Terrible, terrible crimes. I'm hoping to find him again. No, not that lawyer. I'm hoping to find him again with a not so terrible crime. I can't play his cases.
All right. Mr. Deal, we got anything else we can do? I know Mr. Hyman's working on one.
Your Honor, I'm going to need to speak with the state on a few of them if we may take
All
a
right,
brief recess.
we'll take a little break. And as I said, I'm gonna have to leave by 1:30. And I apologize for that, but what we don't get finished today, we'll put on all of it on the 27th.
Yes, sir.
But with that knowledge, Mr. Deal, if that assists you in any way, that's.
We just got here and they're taking a little break.
Oh, I'm good. I'm sorry. As usual.
Oh no. I couldn't. I could not. Nope. I would send the clip to Michael and let him look at it and see if it's worth it, but I couldn't. Oh boy, I gotta. All right, here we go. Smiling here. No. All right, hold on. No, change my mind. Oh.
I'm gonna flag it so I can go back and do it.
I'm looking.
Later would be better.
You gotta understand, the longer we wait, the more interest accrues and the less, the more the plaintiff gets. So the chances of you getting anything diminish the longer we go out. What date would you propose?
Later would be better.
You gotta understand.
Peg leg, is that you? Is that you, Peg leg? Oh my goodness. This isn't Foghorn. I can't get him no more. He's not a judge anymore. Or he's almost not a judge anymore. He doesn't do any court cases. He got in a spot of bother. He got in a little bit of trouble.
Do it, huh?
Defects, retired defects.
I think we need them to come back. Alright, I'm gonna fast forward it until this one here comes back.
You just want to put that on the 20. You're gonna fall behind.
Judge, please.
Court calls or recalls 24R3549, the state versus Hunter Lucas. Mr. Lucas, if you'll be kind enough to raise your right hand for me, please. You solemnly swear or affirm that the testimony you're about to give in this court is the whole truth and nothing but the truth, so help you God.
I do.
You can put your hand down. Give us your name and age, please, sir.
Hunter Lucas, age 24.
And Mr. Lucas, are you a United States citizen?
Yes, sir.
How much education have you had?
High school.
Can you read and write?
Yes, sir.
Can you hear and understand my questions well, we're in the afternoon, this afternoon?
Yes, sir.
Are you suffering from any physical or mental disease here today?
No, sir.
Are you now under the influence of any medications, drugs, alcohol, or narcotics? You are charged with 1 count of theft by receiving stolen property. Do you understand that charge? And do you understand that this court could sentence you from 1 to 10 years in the penitentiary and require you to pay a
10
fine
years.
up to $100,000? And do you understand that you had the right to stand on your not guilty plea in this matter? And do you understand that if you stand on your not guilty plea in this matter, you'd be entitled to a jury trial?
Yes, sir.
And do you understand that you'd be presumed innocent of this charge at a jury trial? And that presumption of innocence would remain with you throughout the jury trial unless a jury of your peers here in Dodge County were to find you guilty beyond a reasonable doubt?
I honestly prefer not thinking before I speak. It makes it better.
Yes, sir.
And do you understand that the state would have the burden of proving your guilt beyond a reasonable doubt?
Yes, sir.
And do you understand that at a trial you'd have certain constitutional rights?
Yes, sir.
And do you understand you'd have the right to confront and cross-examine each witness that the state called to testify?
Yes, sir.
And do you understand you'd have the right to subpoena your own witnesses to come to testify in your defense? And do you understand you'd have the right to testify yourself and present evidence in your defense? And do you understand you'd have the right to be free from self-incrimination, meaning that you couldn't be forced to testify?
Yes, sir.
And do you understand you'd have the right to assistance of counsel at trial, meaning that Mr. Hyman would be there to assist you in the trial of mine?
Yes, sir.
Mr. Hyman's here.
And do you understand you'd have the right to be present during the whole trial?
I do.
And do you understand you'd have the right to remain silent at that trial if you so desired?
Yes, sir.
And do you understand that by pleading guilty here today, you're giving up your rights to a jury trial and these constitutional rights that I've just reviewed with you?
Yes, sir.
And do you have any questions at this point regarding these constitutional rights for either the court or your attorney, Mr. Hyman?
Yes, sir.
Mr. Hyman's with you this afternoon at the podium, representing you. Have you had enough time to talk with him about your case?
Yes, sir.
And are you satisfied with the services that he has rendered to you in regards to this case?
Yes, sir.
Now, on your request in first offender,
He is, Your Honor. I did not put it on there because
I understand what you got. Plea under first offender if allowed by the court. I understand. Well, Mr. Lucas, have you ever been convicted of a felony?
No, sir.
Well, I need to go over some things. I'm sure Mr. Hyman's gone over it with you, but I need to make sure you understand. Do you understand that if you, as a first offender probationer, violate the terms of your probation, the court may enter an adjudication of guilt and proceed to sentence you to the maximum sentence provided by law? And what would that be, Mr. Lucas?
1 to 10 years.
What's the maximum?
10.
10. You mess up
10.
and come back, you could go to prison for 10 years. You understand that? Additionally, I want you to understand that if an adjudication of guilt is entered, you may be sentenced to a sentence greater or more restrictive than that imposed here today. We've already discussed that. You come back for something, any type, misdemeanor, anything like that, you come back and you violated the terms of your probation, you got a chance to go to prison for 10 years.
Yes, sir.
Of course, you get credit for the time served on probation, meaning that if you served a year on probation or 2 years, it'd knock off a year or 2 years from your prison sentence. However, if you successfully complete this sentence that we're going to give you today, you would not have been convicted of a crime. Do you understand that?
Yes, sir.
You understand all of these terms and conditions of first offender?
Yes, sir, I do.
And do you understand that this is a once in a lifetime opportunity? I'll wait until I hear what the factual basis is for the plea before I accept it under first offender. Then how do you plead to the charge of theft by receiving stolen property in case number
I missed that whole part. Can I rewind?
24R 3549, guilty or not guilty?
Guilty.
Are you in fact guilty?
Yes, sir.
And did you on the 28th day of July 2024 here in Dodge County, Georgia, unlawfully receive stolen property, to wit, vapes, a hemp flower product, dip tobacco, cigarettes, and pocket knives, the property of Roddy One Stop with a value greater than $1,500, the exact value being unknown, which you should have known was stolen, said property not having been received with intent to restore it to the owner, contrary to the laws of the state of Georgia.
Yes, sir.
Is your plea of guilty here today freely and voluntarily given?
Yes, sir.
Has anyone tried to force you or coerce you into entering a plea of guilty here today?
No, sir.
If the state would be kind enough to give the court a factual basis for the plea.
Yes, Your Honor. Back on July 28th of 2024, deputies of the Dodge County Sheriff's Office were dispatched to the Roddy One Stop here within Dodge County because the business had been burglarized. Upon initiating an investigation, Investigator Justice noted that various items were missing from the store and that the window was broken, as well as a hasp on the back door. During the course of his investigation, Deputy Lawson at the Pulaski County Sheriff's Office made contact with him and indicated that he had an individual with information about this case. He made contact with that individual who stated that she was familiar with Mr. Lucas as well as a few of his friends, and that she had seen various items that she believed to be stolen from the Roddy One Stop, and that she had overheard a conversation about them possibly entering the Roddy One Stop. A search warrant was ultimately executed at Mr. Lucas's residence, where vapes, tobacco, hemp flower, and various other items were located. Upon speaking with Mr. Lucas, Investigator Justice was able to determine that Mr. Lucas had received those items after his friends did enter that business located in Roddy here in Dodge County.
Did he buy them or?
I don't understand that he bought them, Judge. I just know that he came into possession of those. It may have possibly been in return for helping repair a window at that store.
Repair what?
A window at the store.
So, let me understand. He repaired a window at that store, and so they broke into the store and took tobacco products and stuff.
I believe that Mr. Lucas helped repair a window following a burglary. Who committed the burglary is unknown. And maybe these items were given to him as repayment for his work repairing the window.
You got anything to say about that, Mr. Hyman?
No, Your Honor. I think he was just with the wrong people at the wrong time.
Terry, happy birthday, Terry, with a Y. It's not Terry with an I yet. It's Terry with a Y. Happy birthday. Everybody put it in comments when you're watching this video later. Happy birthday.
Mr. Lucas, as I understand, the recommendation in this matter is that you receive 5 years probation. There won't be any fine. You'll be under normal drug and alcohol conditions while under probation. You'll consent to a waiver of your Fourth Amendment rights, and you'll make restitution in the amount of $3,930, and you're requesting that this court accepts this plea under first offender. Is that the recommendation? And is that the agreement reached between you and your attorney on the one hand and the district attorney's office on the other?
Yes, sir.
Have there been any other promises made to you?
I have no idea what in the world is happening. So he helped them fix a window because it was burglarized. And he was like paid this stuff? Or I don't even know what's going on. I don't understand. Did the people who burglarized it, who broke the window, give him this stuff for some reason? I don't even understand.
You in return for your plea of guilty. I'm holding a document. It's called a acknowledgement and waiver of rights and intent to enter a guilty plea. It's got the caption of your case on it. I'm showing you that document. You recognize that document?
I do.
And this document contains 22 items. And out beside those 22 items are the initials HL. Are those your initials?
Yes, sir.
And did you place your initials HL out beside those 22 items? And in doing so, does that reflect you fully understood and truthfully answered each of those 22 items?
Yes, sir.
Does it further reflect that you have not been misled or induced to enter this plea by fraud or mistake, threat, or coercion? You need to speak up, son. This lady's got to take this down, and I need to hear you, and she needs to hear you. You understand?
I do.
Does it also reflect that you freely and voluntarily answered these 22 questions so as to give this court a basis for accepting your plea of guilty?
Yes, sir.
You signed the document,
That I did.
and Mr. Hyman signed the document.
Yes, sir.
And you understand that this document is going to be made part of the record in your case?
Yes, sir.
Part of the terms of your probation is that you'll consent to a waiver of your Fourth Amendment rights, which means while on probation, you and your property are subject to being searched without consent and or a search warrant. And anything found on you and or your property could be used against you in a court of law. Do you understand that?
Yes, sir.
Do you understand, had you stood trial in this matter and were convicted, you'd be entitled to an appeal, and if you couldn't afford an attorney to represent you in that appeal, this court would appoint you one?
Yes, sir.
And do you understand that by pleading guilty here today, you're giving up your right to such an appeal?
Yes, sir.
Mr. Locust, why should I consider you first offender treatment?
Your Honor, I've turned my life around from that point that I was at.
What point were you at? Were you using drugs?
No, sir. But I was on a downhill, hanging with the wrong crowd. You know, it's a part where my life could not succeed. I want my life to succeed, and I want myself to
You want
succeed.
what, son?
I want my life to succeed, and I want myself to succeed. I want to do better, do good. I don't want to fall off the rim into trouble.
Well, you there.
I am. I'm doing better. Got a better support system, friends, better friends. I'm down to 3 friends. Family.
Well, you had your family
Yes, but
before this.
I did, but I was hard-headed and did not listen. They're guiding me in the path I should be on. I've got a stable job.
Where you work?
YKK in Dublin. Making windows.
If you don't get first offenders, it's going to affect your job.
It possibly could be, sir.
Sure, Mr. Hyman has told you I don't usually give first offenders. But you know, there's one thing good for first offender from the judge, from the court's perspective. You know what that is? If you didn't get first offender, you'd be 5 years probation. And if you messed up, you know, it's not quite as serious if you mess up as a first offender. And if you mess up as a first offender, that gives the court the opportunity to send you to prison for 10 years. You understand that?
I do.
You still want first offender? You're getting an awful big break here. Make a deal with you. You don't come back, I'll give you first offender.
I don't want to come back.
No, sir. It isn't a matter of not wanting to, because I'll bet you you don't want to be here right now.
Yes, sir.
It's about not being back here. You understand?
I do.
I may not remember your name, but I'll remember your face. Mr. Hyman will tell you that. And I see a lot of people.
Yes, sir.
Bye, Hedgehog. I'll miss you.
You get into this much trouble over some vapes, hemp flower products, dipped tobacco, cigarettes, and pocket knives. That just don't make no sense. Why would you risk going to prison for these items?
Really don't know, sir.
I'm going to accept Mr. Lucas's guilty plea. I'll accept it under the First Offenders Act. I'll accept the recommendation. But Mr. Lucas, I'll give you the right to withdraw your plea and you can proceed to a jury trial. How do you wish to proceed?
With the plea that I have given.
All right, the court accepts Mr. Lucas's guilty plea, and the court does so under the First Offenders Act. Court finds that there's a factual basis for the plea, finds that Mr. Lucas has freely voluntarily and knowingly entered into such plea. Court sentences him to 5 years with the Department of Corrections. However, he can do so under probation. There'll be no fine. He'll be under normal drug and alcohol conditions. He's consented to a waiver of his Fourth Amendment rights. He'll pay restitution in the amount of $3,930, and as I've said, I'll accept it under the First Offenders Act. Mr. Lucas, you got 30 days from the date that this guilty plea is official in which to file an appeal to your guilty plea. You also have the right to file a motion to withdraw your guilty plea if you filed it within this specific term of the Superior Court of Dodge County. Do you have a weapons carrying license?
No, sir.
I need to advise you also that in light of the fact that I've sentenced you here today to a felony, you'd have 4 years from the date that this sentence becomes official in which to file a petition for habeas corpus if you feel your constitutional rights are violated. Let's let the plea be entered.
The slow accent is why we love this judge. Doesn't matter what he says, as long as he talks in a slow accent. All right, is there anything further from the state in regards to Mr. Lucas?
No, sir.
Mr. Hyde?
No, sir.
Mr. Lucas, you know where you never want to be again?
In this courtroom.
You need, whenever you think about doing something that you shouldn't do, you need to think, I could go to prison for 10 years.
Yes, sir.
Good luck to you. You need to report to probation. I'm sorry, sir.
Can I ask you a question?
Can you ask me a question?
Yes.
I guess so.
That, you talking about searching him? He's living with me.
Sir, that's part of his probation. If you got guns in your house and he's living with you, you need to find a place for them guns.
Yes, sir. All right, thanks.
I
understand,
That's the law.
that's the reason I asked the
Oh, I
question.
understand. I got no problems with that. But he doesn't, if he gets around the gun, he's to go to prison for 10 years.
Gotcha. Thank you.
Probation's gonna, explain that to him.
Okay.
But, if he's with you, he doesn't, and you got guns in your house, and I'm sure you do, just like I got guns in my house. He either one, can't stay with you, or two, you got to find somewhere else to put the gun. And if he gets in a vehicle and got your pistol in your vehicle, and you get stopped for a traffic violation, that pistol's in your vehicle or truck, whatever, it could be considered a violation of the probation.
Thank you, sir.
And let me tell you, When I say he doesn't need to come back, he don't need to come back. All right, thank y'all.
Sorry, Billy Bob, but you ain't living with me no more. You need to go find your own place.
All right, anything else? Okay. Here?
Is all your stuff in
No, it's not
all your
y'all.
stuff?
It's something else.
That your stuff here or somebody else's?
She's gonna come
I
back on the
have to throw a yellow flag sometime on the civil side.
And they want to prevent, it's essentially the full stuff.
Sir, you can come on up.
I told her that she got it, so she was.
We got a file on it, right? No, I put. Let me see your paperwork. You'll raise your right hand for me, please. Do you solemnly swear the testimony you're about to give in this matter is the whole truth and nothing but the truth, so help you God?
I do.
You put your hand down. You're Kendrick D. Adams,
Yes, sir.
and you live here in Eastman, Georgia,
Yes, sir.
and you were born in 1997 on December the 20th,
Yes, sir.
and so you're more than 18 years old,
Yes, sir.
and you want to change your last name from Adams to King,
Yes, sir.
and your entire life, you're saying your last name was King.
Yes, sir.
But you just now found out that your biological father signed your birth certificate and your name was then made Adams? Is that what we're talking about?
Yes, sir.
Terry, thank you so much.
You're not doing this to defraud anybody?
No, sir.
Okay. All right. You are now Kendrick King.
Yes, sir.
You got some
All right,
good
I'm gonna let
fun.
you have your paperwork back. You're not kin to Mr. Willie King back there, are you?
I'm not sure.
You're not sure? Maybe, hey, could be worse things, okay?
Yes, sir.
All right, you'll go with her, she'll give you a copy of it, okay? You will.
Thank you.
Uh-huh. All right. See you in Pulaski tomorrow.
Yes, sir.
Looks like he's gonna be in Pulaski tomorrow.
Young man nervous enough.
I think you did,
You made me nervous, Judge. Yes, yes, you did.
His daddy's one of the guys I play golf with over.
Vibers are the best. I mean, they're just nothing like them anywhere. Vibers are the best.
That is dumb stuff to.
Just stupid. Risk 10 years of your life for $4,000. I don't see it.
I don't see it either, and I'm not sure what hemp flower is.
I don't know either.
I don't know what, do you know what it is?
I didn't know if it was like regular flour or was it a hemp and a.
No, it was spelled Flower.
I don't know what it is.
It wasn't cooking flour.
One cooking flour.
What that?
Do you know what hemp flower is?
Probably
Yes, sir. That time, not all the time.
Monica, thank you.
He's on probation. I wouldn't have no feelings.
The grandson or their son in their house and they have weapons. And they said, well, they're in a safe. And I said, but I'm not sure if it was the police chief or I don't know if it was, yeah, that's all right.
Technically, it's a probation violation.
I didn't see how could it be, but.
Yeah. I mean, the whole thing is to keep them away from guns, totally. Because once, if they learn that, I mean, it's just, the safest thing to do is not to be around nothing.
Yeah, well, I know one of them, it's in a wood cabinet. Well, that's not safe, with a glass front.
I don't have any guns in my house. My
If
home defense is a can of wall spray and Irish rifle.
If probation the guns and they got problems. So that guy living with granddaddy, I assume, I assume that's who that was. All right, Pulaski, I've gone through the mark. You guys, Judge Johnson, be here tomorrow.
All right.
I'll make that big check tomorrow. Remind me now, I got you out of here by 1 o'clock.
I don't forget that. I just take.
Why don't you donate half the check?
No,
You
what
didn't worry about half.
I do is take a I called Miss Bobby while she said he ain't doing you.
Mr. Bobby?
Somebody said they were.
All right, who can tell me the judge's name? Crawford? Colford? I know it starts with a K, of that I'm certain. I'm trying to remember Joe Kelly pointing at him. Anyway, guys, thank you so much for coming out today. I really, really, really appreciate it. No OJ today. I have to work a double, which is a good thing. That's a yay. Thank you so much. I really, really appreciate it. I will see you all again very, very soon. Have a great Tuesday. Bye.
Got these life echoes, digital dreams. Through the screen, her blue eyes gleam. Wicked humor, sharp as a knife. Her stream sparks electric light. Late night when the world sleeps, she's the friend that always keeps. Giggles roll like thunder loud. She stands out in any crowd. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted sharp. In a way, there's no alarm. Freedom tales waiting to the night. Her laughter feels just right. Even when my world turns gray, with a giggle, she lights the way. Her eyes hear a sky so blue. In her jokes, there's a truth so true. With each string, she brings the light. Turns dark days into bright. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted sharp. In a way, there's no alarm. Screaming tales late into the night. Her laughter feels just right. Even when my world turns gray, with a giggle, she lights the way. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted sharp. In a way, there's no